Hey everybody, I'm Jason McGrath with McGrath and Spielberger. I'm a lawyer licensed to practice in North Carolina, Florida, and Tennessee, and my law firm practices in these other states you can see over my shoulder. In any case, we're going to talk about summary judgment here today. If you are a party in a lawsuit, then you may have filed a motion for summary judgment or had one filed against you, especially perhaps if you're watching this video. And so summary judgment, what that basically means is that one party is saying to the court, saying to the judge, look, the key facts of this case are not in dispute. This is what happened. Judge, take a look at the evidence, which at a summary judgment stage of a litigation proceeding, typically the evidence is going to be in writing in some format, whether it's a deposition transcript or a written contract or something like that. So the party looking to be granted summary judgment will file their motion, file their documents, say to the judge, look at the evidence is not in dispute, there's no big disagreement about what happened here. If you look at the facts and apply the law that is relevant to this situation, judge, you should be able to decide that there really is no doubt that we win. And therefore, this case doesn't need to go forward to a jury trial. Let's not waste the court's time and add more lawyer fees and all this and that. Now, if you're on the other side of the coin and a motion for summary judgment has been filed against you, then your job typically is to go to that hearing on the motion to summary judgment and file paperwork in advance that basically says to the court, no, wait a second. There are some important facts that are in dispute, or important facts whose interpretation is in dispute. And or there is law that's in dispute. Which law applies, or how do you interpret the law and apply it? So often a party responding to a motion for summary judgment will file an affidavit, some of their own evidence and facts and things like that. There are some time frames involved, deadlines involved, but ultimately there typically is a hearing where the judge hears arguments, talks to the parties about the evidence, etc., then makes a decision. If you get summary judgment granted for you, that means you've won the case or won on that claim, just as you had gone to a jury trial and gotten a verdict rendered on your behalf. On the other side of the coin, if you lose a motion for summary judgment and there's summary judgment entered against you, you basically have lost the case or lost on that particular part of the case as if you had gone to a jury trial and had a verdict rendered against you. Now, you might have the right to appeal. You probably usually would. And summary judgments certainly are overturned the same way that some jury verdicts are overturned. But obviously losing on summary judgment is bad. Winning on summary judgment is generally good. So if you're facing summary judgment, you need to respond quickly, assertively, and carefully. And of course the same approach applies if you're going to move to win a case based on summary judgment. So just make sure that your lawyer understands how the summary judgment works. Make sure that you understand it. Make sure that you get educated on it. And if you have questions or need assistance from us, and it's an appropriate case for us to take on, we may very well do that, and certainly don't mind talking with you about it. Thank you, and good luck.